Today we're coming live to you to share 5 top tips from a divorce lawyer, specifically around finances, what to do with your finances if you're going through a separation and a divorce. And today I'm joined by the wonderful Bev Clark, who is of course a director and senior lawyer at Belperio Clark Lawyers. And she has been specialising in family law for how many years has it been, Bev?
About 33.
33 years.
I started when I was 11.
And definitely very, very experienced to bring this topic live to you today. I'm Marissa from Rise High Financial Solutions, and we bring you these live sessions to educate you and empower you to basically achieve your financial goals. And of course, whilst today's topic is a little bit difficult for some people, because it is a difficult time in a person's life if they are going through a relationship breakdown. It is a really important time to understand what it means from a financial perspective, and what things you can do to prepare for that and make sure that you end up out of the process, in the best possible position.
Yep.
So thanks for joining us today, Bev.
My pleasure, Marissa. Thank you for the opportunity.
Let's just start. I mean, it's been a crazy year.
Yeah,
obviously.
has, yes.
Have you seen any changes or differences as a result of COVID and the craziness that we've experienced over the last year as to how that's impacted relationship breakdowns or any changes in that space?
We haven't, not in terms of a sudden influx of new work driven by proximity of people after separation. Not at all. We've seen more problems about kids' issues when parents are interstate particularly, and there are travel restrictions. So that's been our bigger concern. Nothing else really. Yeah. Business as usual.
Well, that's a good start, really, isn't it?
I sometimes wonder if it's good or bad. The reality is relationships break down. They break down in good times.
What are the stats these days?
But they say 1 in 3, but the stats are only taken by marriage.
Okay, so there's also de facto as well.
And there's de facto, and we think there are more de facto relationships. So anecdotally, I think about 1 in 2 relationships break down.
Yeah.
That's my gut.
So just with the de facto status, at what point of living together with a partner does the family law become an issue? If you're living together with someone for 6 months or for a year, is there a time frame at which your relationship status changes to becoming more financially serious?
Well, good question. 2 years living
2
together,
years? Okay.
Or have a child together, or make substantial financial contributions. So it doesn't have to be 2 years. If 2 people start living together and one person has stumped up $50,000 to put down a deposit on a house,
they're sharing that house.
Yeah. They would have a claim under the Family Law Act.
Okay, so there's a few different
so
shades of grey there.
Yeah, correct. Yeah. And de facto relationships are particularly fraught with difficulties, I think, from a family law perspective, because unlike a marriage where you have a ceremony and there's no doubt about when it starts, with a de facto relationship, there are frequently arguments about when it started and when it ended, partly driven, I think, strategically by people who it's in their interest to say the relationship was shorter or longer, depending on what their financial perspective is. So that causes another problem.
So that's something to be mindful of if you're not in a marriage but you are in a de facto relationship, just understanding that and maybe getting some advice around that.
Yeah, correct. Or doing something that has some way of recording when this relationship actually formally started to be a de facto relationship, and that's really tricky.
So before we actually get on to what to do if the relationship's failing, I'd really love to start with some positive, proactive things that people can do when they are in a relationship and they're starting to combine their finances, because I guess relationships evolve and you get to a point where you decide that you will combine your finances, or maybe some couples never do, but
correct.
You can get to that point. So from your perspective, having seen it from the other end, do you have some tips or advice for our audience as to what they should be doing at the beginning of that relationship journey when they are getting to that serious stage of thinking about the future and combining finances?
Yes, Marissa. I think for me, when I see things at the end of a relationship, one of the arguments that people frequently enter into is an argument about who had what at the beginning. So one person will say, well, I had $100,000 in savings and I had a house with this much equity, and there's no evidence that proves that. It's just what they say. And the other party, of course, denies it. And then that can be a factor that can make a difference to the outcome when they're dividing up their property at the end. It could be a factor that's taken into account in an adjustment. So one tip would be, and it's awkward because you don't really want to start a relationship where you're full of love and optimism with this idea of what if it goes wrong. But if you want to protect yourself financially, one option is at least have everything you own valued, gather together a kind of portfolio of what you have, how much your mortgage is, provide evidence of that. Evaluation on your house, copy of your mortgage statement, copy of your superannuation statement, copy of your bank statements. Package it together and put it somewhere so that you've got it for safekeeping. And ideally, if you can get the same for your spouse or future partner, same thing, at least there's evidence about what precisely will be the starting point in that relationship. People can get what's known colloquially as a prenup. But there's no guarantee about those documents. They're really expensive to produce.
I mean, how much do they cost on average? Just a
It depends
ballpark?
on where you go, but anywhere from probably about $10,000 to $20,000.
Okay, so
there will be some lawyers will do them super cheap, but they won't be. They'll be full of holes, in my opinion, because they're a document that's trying to anticipate all the possible things that people need to factor into. And the mere fact that people want to negotiate a prenup sometimes in itself causes issues in the relationship. So strategically, people have to worry about that. I think a prenup is more secure in relationships where they're older couples coming together with established asset pools and separate kids and no prospect of having children together. I think they're easier to navigate than they are, and therefore cheaper to achieve than they are when you've got a young couple just starting out with the possibility that they could have kids and all sorts of things could happen.
I think your tip of putting together a little portfolio of all of your assets and liabilities and your savings and everything like that is a really sensible idea, not only from a relationship perspective, but it's just good finance management to actually, I would actually recommend that to anyone, regardless of whether they're in a relationship or not, just actually because it's surprising how many Australians know how much super they have or what their actual loan or account balance is. So actually having that little portfolio at the start of a relationship, but then also perhaps updating it or having updated versions is actually just really good finance practice and finance management anyway. So I think that's a great tip.
And I also think that sometimes at the beginning of a relationship, people are a bit awkward about money. Talking about someone else's money, how much money do you have in the bank, is kind of a sensitive topic to raise, and some couples go into a relationship having no idea about the asset position of the other party, and sometimes, as you know, the trappings of wealth, someone driving a fancy car, living in a fancy apartment with a Rolex watch, doesn't mean they're rich.
No, that's
it
right.
It may well be it's all on top.
Might be a facade.
Exactly. And so I've seen clients where if they had actually known that their partner has enormous debt and no wealth, that actually might determine whether they choose that relationship.
That's right.
Because what you see isn't always what you get. And so sometimes I think having that kind of disclosure at the beginning of a relationship might seem a bit awkward and a bit businesslike, but you wouldn't go into a business partnership with someone that you didn't know enough about. And I think we go into relationships sometimes with rose-coloured glasses.
We have a little saying for that in the office: it's sexually transmitted debt. And it's really important to know what your partner's financial habits are.
Absolutely.
And it's really good to have those open conversations early in the relationship, as hard as they are, because you need to understand, are you a saver or a spender, and what is your partner, and how are you going to communicate about money? Often we find as well that if we're dealing with a couple, there might be one person in the relationship that's really quite confident and strong with managing money, and there might be another person in the relationship that doesn't feel as confident or isn't as involved or actively involved. And we always like to try and encourage everyone to understand.
Absolutely.
So, if you are sort of the nature of sitting back and letting your partner do it for you, I just think it's so important that you actually take the initiative to learn
I agree.
about your situation and understand what's going on, because, you know, the amount of times we come across situations where a wife finds out that her husband's gambled away all of their money for the last 20 years and has only just realised it.
Absolutely.
You know, like it seems strange that would happen, but it happens so frequently.
All the time. And it's I think, totally appropriate advice, and I agree with that wholeheartedly. I think, especially if you're the party that is going to take the back seat, it's all very well and good to trust someone, but I think it's about having an eye on what's going on. Otherwise, you put yourself in an incredibly vulnerable position.
Yeah.
I saw a lady this morning, no idea what they own, what the husband earns, you know, long relationship, 2 older kids, no idea. And I think that's incredibly sad for someone to come out of a relationship and feel financially vulnerable without any clue as to what their financial picture is going to look like.
And I don't think it's a matter of trust, even early on in the relationship, to be able to talk about these things, because if your partner isn't comfortable talking about this with you, then that raises a question.
Absolutely.
Because you think, what are they trying to hide?
Yep.
I
Also, what kind of person is it? Is this a partnership?
Yeah.
Because if it's a partnership, I ought to be comfortable about saying, how much do you earn? And you ought to be comfortable to tell me.
Yeah.
The answer shouldn't, I can tell you, if it was my spouse saying to me, that's not for you to know, I think that would be kind of a deal breaker for me.
Yeah.
I want to know that that's the person I'm choosing to start a relationship with, because if that's the attitude that they're going to display, especially for younger women, it's usually women, not always, but usually. But for a younger woman going into a relationship where she might have children, give up work for a period of time and then be financially dependent on someone.
Exactly.
You want to make sure that you're choosing Mr. Right.
Yeah, that's right. Yeah. I mean, it's equally as important for men to understand what are the financial habits and the financial position of the female.
So true.
Because, you know, that can often cause issues in relationship if you find out those things after marriage.
Yes, I see both sides of that. I see the husband who considers himself to have worked incredibly hard to provide for the family, scrimped and saved and not had any luxuries in life to make sure that he's paying off the mortgage and all those things, and then discovers that his wife is a spender. And spares no expense, and so suddenly at the end of a relationship, the Prada handbag that she just absolutely had to have, to him is a real thorn in his side when he gave up, you know, some of the things that, and he's been the one working and earning the money. So it creates all sorts of drama. So knowing, I guess, the financial attitude people have during a relationship is a big assistance to determining that.
So I guess that sums up tip number 1, which is really early on in the relationship, or really it's never too late, to actually have good communication with your partner about your finances, to understand, both of you should understand the financial position of each other and yourselves as a couple. And I like to suggest that people have regular money date nights, where they actually, you know, maybe once a month they might get together to talk about, you know, their financial goals as a couple and how they're sort of gearing towards that. But I guess tip number 1 is just to really try and understand the financial position before things get messy, I guess. So let's go on to tip number 2, and this is sort of progressing on to, okay, if the relationship is breaking down, what should people be doing at that point when they know that the relationship's, you know, is looking to head that way?
I think the very best advice anyone could give would be to get good advice at the time, specific to your needs. Get good financial advice. Go and find out. There's no point even commencing negotiations or planning for an independent financial future if you don't know, what is my borrowing capacity, what is my financial position, what does my budget need to look like going forward, how much money do I need to run my household if you've not been the one in charge of those decisions. There are lots of people who have no idea how much it costs to run a house, how much it costs to send the kids to school. They just don't know that stuff. So getting good financial advice, getting good legal advice, and I genuinely mean that. I say it's not about just people dispensing the law. Any lawyer can tell you what the law says, but it's about having a wise guide who's not just going to send you down the wrong path or down a very litigious path, because there's many ways people can go about resolving their matter. And I always think people should start with the least invasive, least expensive approach and only move up the chain of invasion and cost if those lesser expensive ways don't work, such as mediation, collaboration, independent negotiation, just two parties sitting over a cup of coffee and sorting it out. So getting the right process.
I find that people are reluctant to go to lawyers because they're worried it's going to cost a lot.
Yeah.
And they're worried about going to court and what process that will be. And unfortunately, I guess in every industry, there's a few bad eggs out there that, you know, ruin it for the rest.
Yeah.
How do people find where it won't sort of cost an arm and a leg, or the lawyer's not going to send them down a garden path, which is going to escalate the costs and aggravate the situation?
There is an Australian Association of Collaborative Practitioners now, AACP.
Okay.
If they go to their website, that will give you around the country information about who collaborative lawyers are.
What is a collaborative
lawyer? A collaborative lawyer is a lawyer who is trained not only as a lawyer but has also done additional training to be a collaborative practitioner. And so when we're working in a collaborative case, we're looking very holistically at a family. So we consider ourselves not to be the alternative, which is the pit bull litigator, in my opinion, is the person who, if they only have the tools in their toolbox to write letters or go to court, then it's kind of funny, but that's what they sell people.
Yeah.
And I think they're inevitable for some couples, but they're last resort approaches. Whereas once people do collaborative training, they tend to have a different approach and much more committed to helping families resolve matters in a more respectful way. So it's a true collaborative case is actually a non-adversarial process where lawyers both are trained in collaborative and help parties resolve matters out of court. But collaborative lawyers, even if collaboration isn't necessary, it's too much process for any family, collaborative lawyers are much more likely to be strongly recommending mediation or just negotiation between the parties and supporting them in doing that. Yeah. And so they're not just sending them off down that litigation path.
And that sounds like a much nicer outcome for the family, especially if there's
if
children involved.
100%.
And probably cheaper
in
the sense
absolutely.
that if they can avoid court, that's
absolutely.
always a better option. So, okay, so that's a good tip about getting legal advice. So
and starting on the right path. And the other thing is, before you possibly, unless there's urgency about it, before you get your legal advice, it would also help if you have some information about what's in your asset pool. So the first question anyone's going to want to know, and you should want to know, is what do we have and how much is it worth?
Yeah.
And so there are ways we can get that information if it's not forthcoming from the other party, and that obviously everything lawyers have to do adds cost. But the more people can do themselves in terms of ascertaining, you know, how much is our house worth, how much is our mortgage, how much superannuation do we have? There's information you can gather that will help to inform any professional advisor of what the starting point is and therefore what's achievable.
Yeah, that's really good. So just to summarise, tip number 2 is really about getting the right advice.
Yeah, getting the
right
advice.
So it's really about financial advice, and of course at Rise High we can help you to understand your borrowing capacity and look at all of the different options of, you know, different scenarios and hypotheticals of what you might be able to achieve individually post a relationship. Getting the right legal advice, as Bev said, and a collaborative lawyer will definitely give you the best chance of collaborating in a less aggressive way. Finding an outcome.
Trying to navigate we do this every day.
Yeah.
So this is not new to us. But for people going through it, they're going through the worst experience of their life. They can't think straight. They're stressed and anxious and scared often, or angry.
It's a very stressful time.
It's a very stressful time. And so they need someone who isn't going to just pump up the fight, but is going to try to reality test, be sensible, be reasonable, and try and find them that sort of path through to the end where they do the least amount of damage to the family. That's our motivation, really.
Tip number 2 is really getting the right advice. So let's just move forward to tip number 3, because I'd like to leave a tip here of when is the right time to get a lawyer involved. Do you have a thought process on that? Because obviously we've just talked about the fact that legal advice is important, but at what point should you see a lawyer? Is it at the point where you have made the decision that you're going to leave your partner, or that they've told you they're going to leave you, or is it at the point that you've been separated for a year? I mean, what is the point where a lawyer should actually get involved to give you some of that legal advice?
Anywhere up to the point where you just say, yes, I agree to that and sign something. Anywhere up to that point.
So
I see
before you
people
actually
who, after
agree...
they've made a commitment to something and they've signed something, then they come and say, oh, now I've done this, is this okay? Or I don't like this, how do I get out of it? Before you go signing anything. But realistically, it depends on the family. Some people, I see lots of clients who come long before they've even left, because they're wanting to know, am I going to be okay? If I make this decision, am I going to be okay? And so they want to talk through what's it going to look like, what might it look like, and how they might go about it. And sometimes we even refer them to, if the marriage might be salvageable, we know lots of counsellors that are fantastic that we might send people to who can help them to either work with their spouse to see, can we repair whatever damage is being caused in this relationship that's sending one person down the path of thinking about separation. And if they can't, sometimes counsellors can be really good assistance to help someone let their partner know gently that it's over. So I call that a managed exit. Instead of just coming home and saying, honey, I'm leaving you, bye, having someone who can help the couple work through the issues and then both come to terms with the fact that this is probably best for us to separate is much easier than one person imposing it on another. So sometimes getting the right lawyer involved in the beginning stage will also help people to tap into other resources that might help them. I mean, for example, Marissa, I send a lot of people here, as you know, when they are going to need to either buy their partner out of the house or they're going to need to acquire a home for themselves beyond their separation, and they just don't know where to start. They don't know what's achievable. And the beauty of your business, of course, is you've got access to lots of different lenders, and so the lending criteria might not be achievable if they just rock up to their local bank and say, can I have a loan? But if you can investigate for them, they get a lot more options. So I found that invaluable. But sometimes if they go to get advice from their accountant or a counsellor or their financial advisor, sometimes those roads lead to each other and we set the parties on the right path. So I think early advice, depending on the quality of the advice, as long as they're getting sound advice, it's not really too early.
And I think what you said, like we do actually help a lot of people that separate on good terms.
Yeah, absolutely.
And they're very amicable and they'd like to remain friends out of it, and they actually are able to come to an agreement themselves.
Brilliant, yes.
So in that situation where you do have a couple that are happy to come to an agreement themselves and they're even happy to document that agreement themselves, is it still advisable at that point to, what should they do to formalise that agreement? Because if they can successfully reach that agreement without actually having to get lawyers involved, and they're both happy with that outcome, what can they do to make sure that if they end up in other relationships in the future, they're not going to have another bite at the cherry?
There's only two ways of finalising family property. So if you've been married or in a de facto relationship, if you don't mind taking huge risk, you can shake hands, do the deal, hand money over, sell properties, do what you want to do, and never record it. But you're always going to be on edge, because there was a case I was listening to the other day where 20 years after the parties separated, someone applied to extend the time to make an application.
Wow.
So you've only got 2 years after you separate from a de facto relationship to issue proceedings or settle a matter, but you can get an extension of time in certain circumstances. You've got 1 year from the date of finalisation of a divorce to be able to issue proceedings or have finalised matters, but you can get an extension of time. So my view is that when people have finalised their property and they've reached an agreement, it's false economy to not record that in a binding way. And so the two ways are getting a Section 90 agreement. I'm not so keen on those, or getting a consent order in the court.
So what is a Section 90 agreement?
Section 90 agreement is a binding financial agreement. It's fairly technical in its requirements. It still requires full disclosure by both parties. I think they're more expensive to prepare, and I think that they're more risky for parties. I think it's cheaper and easier for people to get a consent order, because that requires 2 documents, one of which I often encourage clients to do themselves, the application. It's downloadable from the Family Court website, application for consent orders under forms. They can have a look at that. that requires a fair bit of financial disclosure in that document, so
Yeah.
it lets people know what they need to know. If they can fill that out themselves and they only have to get the lawyer to draft the actual order, then it's very straightforward.
So they still will need a lawyer involved.
They ideally, yes. Look,
Yeah.
it's otherwise if you draft your own orders, it'd be like drafting your own insurance policy. I think you leave too many holes in it, and you don't know what you don't know.
Yeah.
I've seen lots of orders where people assume that they've drafted something that does what they think it does, and then when they're trying to enforce it later, it's I'm
And I
looking
guess
at it
the
saying it
order
doesn't.
that is drafted at that point would be both sides. You know, what both sides get, or would each
No,
person
it
have to get
provides-
their own order?
No, it's one order that both parties sign. Now, a lawyer can't act for two people, but I see lots of people like you do that have reached an amicable agreement. They just want it recorded, and I will often see both of them on the basis I only act for one of them. I'll prepare the documents with the input from the other person on the basis that they're not represented. If they have a lawyer, we can't do it that way, but we can work with their lawyer. But they both come, we prepare the documents, and then the other person who's unrepresented, if they want to, of course they're welcome to take it to a lawyer and get it checked over.
Yes.
Sometimes they do, sometimes they don't. But in those documents, in the orders, we're protecting both parties' case.
Yeah.
We're looking at,
Yeah.
you know, if one person's buying the other out of the house, for example, it's really important that the order talks about when is the payment going to be made, and what happens if they don't make the payment. There's no point having a document that says you'll transfer the house to me and I'll pay you this much money, and then it doesn't say, well, hang on, what happens if you don't? Or you can't? What if you legitimately can't discharge the mortgage and you can't pay the money? Well, there has to be a default order, and so we protect both parties in all of our orders to make sure that all of their needs and interests going forward are protected. But it gives certainty, because people have separated, they don't have much money. And I had one recently where a young girl, they only had about $200,000 between them, but she inherited multi-millions before they'd finalised their deal. And then, of course, the husband said, you're much better off than I thought you were. I want some of that.
And
so
he can access that?
Yeah, whereas if they had done the deal and signed up on it and had an order made before that happened, that wouldn't have been an issue.
Wow.
So there's a lot of things that can happen in life, as you know.
Well, I sort of see, we sometimes see situations where the couple's really amicable and it's really lovely, as lovely as a separation can be in terms of they're just really cooperative and amicable. But then years down the track, they might meet other partners. And they might potentially have more children. And then their partners might have a different idea and might, might have gone through divorces themselves and, encourage their partner to then, pursue more. So you just don't know what can happen in the future, even though you know someone now and you feel like it. So I guess that the tip really then is to make sure that you do get legal help at some point. If you feel like you can resolve it amicably amongst yourselves, then you still need to get a lawyer involved to do the order.
Yes, you do.
But if you don't feel like you're going to resolve it together yourselves, then you really should get a lawyer involved probably a bit sooner so that you're actually put on the right path to get the right advice. Is that how you'd summarise that?
Yeah, absolutely.
Yeah, okay. So what do people need to, I'm just reading my questions. We've covered quite a few of them. And by the way, we've had quite a few people tune into this session today, but for the purpose of today's topic, I'm not going to do any individual shout outs because I know that it's a confidential topic and some people may not want the world to know that they're listening today. So thank you for joining though. And if you do have any questions and you want them to be confidential, you can email them through to emily@risehigh.com.au and we will do it as an anonymous question through the email. If you don't need it to be anonymous, you can of course leave a question in the comment section below and we will answer that question too. So can we talk about superannuation?
Yeah.
Is that included? Is it not included? I think there's a lot of misunderstanding about superannuation and how that comes into play in this situation. So can you shed some light on that for us, please?
Yes. I see a lot of misunderstanding about it. I see a lot of couples who've reached an amicable agreement, and then when I'm doing the documents and I say, well, how much does your spouse have in superannuation? They say, I don't know. Well, how do you know that this is a fair deal if you don't know what they have? And so my question is always, if they had $1 million in super, would you still be okay about them keeping it? Usually the answer is no. So you need to know that stuff. So superannuation is absolutely part of the package. I know a lot of couples where in their amicable agreement, when they haven't had advice, the reason why they think super gets to be kept by the person who earned the money and invested the super is that, well, I earned all the money and so I've acquired this superannuation and so that's mine. Well, it doesn't work like that, because under the Family Law Act, we take into consideration indirect contributions. So if one party's been home raising the children and the other party's been working, that's seen as an equal contribution. Yes. Nevertheless, everything any party has, including superannuation, including even long service leave actually benefits, might be relevant, is in the pot. Superannuation is mostly dealt with as what we call a second pool. So the court usually, if we were fighting about it in court, would deal with the non-superannuation assets because they're more liquid. You can get access to them now. And they would deal with superannuation differently. Okay. And so, and superannuation splitting orders can be made to equalise or adjust superannuation, or people can use superannuation to trade off with other assets if they wanted to. Self-managed superannuation funds are a bit more tricky and absolutely need careful valuation. And so a lot of times we see a self-managed fund where the value of the fund is based on some real estate that hasn't been valued for a while. And so it's based on dated
especially
information.
If there's property or...
exactly. And so for the purposes of looking at what is in a self-managed superannuation fund, that adds, we just need to then get all the underlying assets valued to look at them. But superannuation can be split between parties. It usually is.
Well, that's probably a nice segue to another question that's come through, which is about what is the process to separate the assets? So let's say that they've actually, a decision's been made. Let's even say that a court order's been granted. What's the process?
It depends on what the order says, or depends on what the parties want to do. So some assets, for example, 5 minutes after they've separated, parties have closed their joint bank accounts and divided money, or they've worked out their furniture and effects and they've divided that. If they haven't, a court order, or whether it's by consent or a contested order, can specifically set out, within 30 days of the date of this order, this happens or that happens. So it could be, people have to deliver up the piano, or somebody has to transfer the registration of a car, or
what about with bigger assets like property and shares? I mean, I know that from we sort of get involved when it's a property transfer. And the way the banks look at that is they sort of look at it as a sale, because it's a change of ownership. So normally you've got to get a conveyancer involved. But do you normally do the conveyancing?
No, not now. We used to, but it's just got too complicated in a sense. And so we don't do that. We get a conveyancer involved.
So they need to get a conveyancer involved. We get involved to help transfer the loan over. And that normally, so the date that would have to happen by would be documented in this agreement.
In the order. And we usually are very careful these days, because in the old days, you could get a property transferred in 30 days. And so commonly orders would say within 30 days, the property's transferred, the money changes hands, the person keeping the property refinances. These days, I'm not putting less than 90 days, because you just can't get the banks.
The banks can't achieve a 30-day settlement now.
And the consequence, and for anyone listening, if you do have other lawyers drafting orders, for example, and they're putting 30 days and you're the one that has to pay the money and discharge a mortgage, don't agree to 30 days, because in most orders
it can take a little while.
The default of you failing to achieve that, even if it's not your fault, is that interest will run on the money you were supposed to pay your spouse from the date of when you were supposed to pay it. So if the bank takes 90 days and you're meant to pay your spouse $500,000 and you don't pay for and you're meant to pay within 30 days, but it takes 90. For 60 days, you're paying interest, and it's at a penalty rate. It's not market interest. It's designed by the court specifically to give you a little punch in the guts, because they want to make sure you pay.
And we also find that many lenders, when a couple is going through a divorce and they're going through an asset separation, many lenders want to see the formal agreement.
Correct.
So many lenders want to see the court order before they will approve the loan. So we can't really get the approval until we get the court order, and then we start the process at that point. So, I mean, of course we can do, pre-approvals, and we can do our preliminary assessment and our calculations, but realistically most banks want to see the signed agreement, because they want to know that the partner's not going to have recourse to this property following the settlement of the property. So I think your advice about having longer settlement dates is really sensible.
Yeah.
And it takes the pressure off the parties. Still should act quickly,
Yeah.
but it just means that it's a bit more achievable.
Yeah. The other advice I give people is just be careful about, I see a lot of clients where they've signed up to buy another house, not subject to their family court order being made.
Yes.
And they haven't got their first settlement sorted out, and now they're on the back foot in any negotiation because their spouse is well aware that they've signed a contract that they're going to be in breach of if they don't get this deal over the line, and some unscrupulous spouses will take advantage of that. Oh, you're in a bind, aren't you? Well, I'm only prepared to pay you this much. So
it's interesting that you brought that up, because we often get the situation where a couple is separated and one of them or both of them are just really desperate to move forward with their individual lives before they finalise their separation and divorce. So, and they're wanting to buy another home to live in themselves. I mean, what advice do you have for people in that situation? Is that okay for them to do, or is it sensible just to... Because sometimes these divorce situations can take years.
Yeah, absolutely.
I mean,
if the wheels fall off their amicable agreement and they're fighting about it in court, it absolutely can take years.
So if someone isn't prepared to wait that time frame to like move forward, and maybe they don't want to be in their existing house and they want to buy... I mean, what advice do you give in those situations?
Well, they can. There's nothing stopping people moving on. There's nothing to stop them moving out, buying a house, doing whatever they want to do, if they've got independent means of being able to do that.
Yeah.
The problem is when they're incapable of buying another house until this one is sold and the proceeds of sale have been determined as to who gets what, or the other party is going to buy them out and physically refinance and pay them. If they're dependent on that, then you just don't have the luxury of moving forward. In some circumstances, you can go to court and look for some interim orders to address some of those immediate issues, but it depends on the overall asset pool, what's available, what isn't. So it sort of depends. They need to get some advice about that. But as a starting point, I would say unless you've got the means to fund it yourself by something you've got access to, don't rely on a joint asset or the goodwill of the other party to make that happen for you unless it's recorded in a binding way and the deal's done.
Yeah, but I mean, I guess ideally you'd finalise your asset separation before moving forward in an ideal world.
Yeah, in the perfect world, you absolutely would.
Yeah.
And it's also that issue about when one person is seen to be moving on and got their life together, sometimes that can create some resentment that didn't exist in the other party. So sometimes letting the dust settle, it's a bit like, don't introduce the children to your new girlfriend until, your wife's moved out of the house, I would say.
Yeah,
it's that kind of, don't be in such a hurry.
And, sometimes, unfortunately, we sort of see lots of different situations here, as I'm sure you do, but we've spoken about the amicable separation, but sometimes we do have clients come to us and their partners are just not receptive about discussing anything or acknowledging the separation or discussing the asset separation, or are so unreasonable in their request that it's really hard for them to move forward. I mean, what advice do you give people in those situations?
When you have to work with what you've got.
Yes.
Right. So you can only change you. You can't make someone else engage, be reasonable, agree on anything. You just can't. So when you're dealing with someone, but sometimes it's about understanding why. Do you know, sometimes people are in a hurry because they've processed the end of the marriage and they're ready to move on with their new life, and the other person's just had the rug pulled out from under them and they're a bit like a deer in the headlights and they're not quite sure what to do.
They haven't had a chance to process it.
Yeah, and that's sometimes perceived as being them stonewalling and being unreasonable, but in reality they just might not be capable cognitively of functioning at that point. So having an understanding about that. If you've got someone who just will not engage, well then you're not going to be able to sit over the kitchen table and sort it out yourselves. You're going to need some further help. So obviously the next cheapest alternative is if you can invite them to mediation. Mediation is a great avenue to help people come to terms with, okay, we now need to make these financial decisions. What can we agree on? What can't we agree on? If they won't turn up to mediation and they won't engage a collaborative lawyer, well then people have only got the last two options, which is get a lawyer to write to them and see whether that jogs them out of their malaise. And if that all else fails, and or there's issues of urgency that absolutely have to be addressed, or risk, then it may well be a court application is necessary. So there are ways and means of achieving it,
steps that you go through.
But you want to try, obviously, up the lesser invasive and lesser provocative. It's like it's easy to start a court process to try and make someone engage, but once you've started that war,
you can't
be
take
careful.
it away.
You can't unring that bell, and so you've got to think carefully before you do that.
I think that's really good advice, and I think one of the things that I love about you is that court's the last option.
Yeah, absolutely.
You know, whereas some lawyers do sort of jump to that as the first option, and I think that's definitely not a helpful. It's not a helpful approach for either party, really.
No.
So that's really good. We've discussed so many great tips today in today's session, and once again, thanks to all of you for joining us today. We hope you found value in it. We're actually giving away a free handout today, which will be available in our blog post. So there will be comments in there that will be really useful to you to summarise some of the points and give you some extra tips. But to summarise, before we wrap up today, can we just leave the audience with your 5 top tips? I guess we've discussed most of them, but let's just summarise the 5 top things that people really takeaways that we really hope they've taken away from today. Just to sort of leave them with those 5 tips.
Have your eyes open in any relationship financially.
That's a good one. Yeah.
So don't have those rose-coloured glasses on all the time.
Yeah.
Get good advice, both financial and legal advice, before you make any decisions. Try to manage your negotiations, I think, in the most respectful way that you can, because you win more bees or win more flies with honey, or whatever the saying is.
Yes.
So I would say do that. And be realistic. I think when people are negotiating any kind of outcome, if they're only promoting their own best interests, it's really hard to get the other side to say yes.
Yeah.
Sometimes you also have to kind of put yourself in the other person's shoes and imagine, okay, if I was on the other side of this fence, would this feel okay for me? Is there something in it for both of us? Because when people pitch proposals that are really heavily weighted in one favour without grounds, then that can be that's an impediment to a settlement, and then you've got to factor in how much is it going to cost me to have the fight.
Yeah.
So when you're looking at any proposals, I think also look at them from a perspective of, if I don't accept this and I end up having to spend a lot of money, am I any better off?
Yeah, I think that's great. Thank you so much for that. Thanks for joining us today, Bev.
My pleasure, Marissa.
Thanks for joining us today. So if you do want to get in touch with Rise High or Bev, or any of the legal team that they have there, we would love to help you, and we can have confidential chats with you anytime. And of course, there will be a free giveaway that will be very useful to you, so make sure you get your hands on that. And thank you very much for joining us today, and we'll see you again next time. Thanks, and have a great day. Bye.
Thanks, everyone.